But the 14th Amendment, Section 3, is pretty clear. If you engage in acts of insurrection or rebellion against the government, or you give aid and comfort to those who do, you are disqualified from running. It doesn't require that you be convicted of insurrection. It just requires that you have engaged in these acts. It's a disqualification from holding office again, and it fits Donald Trump to a T.
All right, so that's Congressman Adam Schiff there on the 14th Amendment, claiming that former President Trump has already disqualified himself from holding elected office in this country ever again. Joining us now for more on what that means is former New Jersey Superior Court Judge Andrew Napolitano. Judge, great to have you back on this morning. So Adam Schiff was everywhere on Sunday, and the 14th Amendment, it does state that anyone who has, quote, engaged in insurrection against the U.S. is barred from holding elected office again. And the fear is, and people don't take Adam Schiff seriously, at least conservative America doesn't, but the people listening do. And the fear is that a Democratic Secretary of State in one of these blue states could actually keep Trump's name off the ballot if he is in fact the nominee on Election Day. Take us through what's going on here.
Well, what's going on here, and good morning, Rob, always a pleasure to be with you. What's going on here was provoked by a law review article written by two conservative law professors who are members of the Federalist Society, arguing, just as you said, that a state secretary of state on his or her own, without any due process, without any trial, without any conviction, without any proof, just on the basis of what the person has perceived from the media, can keep Donald Trump off the ballot if he is the nominee in 2024. This has divided the legal community and has not divided it along ideological lines. There are conservatives who side with this. There are conservatives who oppose it. There are liberals who side with it. There are liberals who oppose it. I'm, as you know, a libertarian. I believe that government is best which governs least. But just looking at this, it is clear to me that the framers never intended to give a bureaucrat the decision to decide who goes on the ballot. It's for the people to decide, or for a jury to decide.
Right.
So if Donald Trump is to be kept off the ballot because of something he did on January 6th, he would have to be tried and have the opportunity to defend himself and be convicted before that can happen. It can't happen just because a state Secretary of State read something in the newspaper or saw something on television they didn't like about Donald Trump. That's not the Constitution.
Donald Trump's being accused of election interference. I don't see how this wouldn't be election interference. Imagine if it were to happen in a battleground state, Pennsylvania, Wisconsin, Michigan, states that went one way in 2016 and went another way in 2020. Will the Supreme Court judge have to get involved here?
If a state Secretary of State and the Secretary of State of New Hampshire, which has become a battleground state, has indicated that he is seriously looking at this, even though the governor of New Hampshire says he's not in favor of it. If a state Secretary of State were to strike Donald Trump's name from the ballot after he is the Republican nominee, I am sure there'd be a challenge, and I'm sure the challenge would go all the way to the Supreme Court. And It's virgin territory. It's never been ruled on before by the Supreme Court.
Yeah, a lot of that going around. Take a listen to how another judge characterized this situation over the weekend. This is on MSNBC. Take a listen.
This is one of the most fundamental questions that could ever be decided under our Constitution, and it will be decided by the Supreme Court of the United States sooner rather than later, and most likely before the first primaries, in which Donald Trump would be put on the ballot or disqualified from the ballot by one of those secretaries of state.
What do you make of that, Judge?
Well, that is Judge Michael Ludig of the Fourth Circuit Court of Appeals, now retired, a Ronald Reagan appointee, a conservative icon who happens to be in favor of this argument. I profoundly disagree with the argument. It would be so unfair to Donald Trump or to anyone that they should lose the right to have their name be put on the ballot after they became the nominee, just because of what some state official read in the media.
Right.
Clearly, the framers, when they put this in the 14th Amendment, were trying to prevent those who fought for the Confederacy from coming back into the government. And they succeeded in doing so. It was very clear in those days. You fought, you were in the Army. We know you did it. We don't have to have a trial. But January 6th, there would have to be a trial, and Donald Trump would have to be convicted of something before he could suffer the slightest legal disability.
Great point, because right now, presumption of innocence, obviously.
Correct.
Judge,
Correct.
Appreciate you being on with us. Something tells me we're going to be talking about this again very soon. Thanks for breaking that down. Appreciate it.
Of course, Rob.